Hello, this is Alexander Cross, criminal defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So, we received an interesting inquiry here on our YouTube channel. This has to do with the stabbing in self-defense. Let's see here. One night, I ran into my ex-boyfriend, and he wanted to take me by force. I defended myself with a knife and stabbed him. The police arrived and I was arrested. Well, let's say, yeah, he did try to kidnap you. Well, yeah, that's a felony. It's a dangerous crime. Yeah, you would absolutely have the right to defend yourself, including you'd have the right to use lethal force. When you are at risk of suffering great bodily injury or death, yeah, you have the absolute right, based on the defense of necessity, to use lethal force against him. Now, it doesn't say anything here that you killed him, but even if you had, you would have had the right to do it. Under the circumstances. Of course, if you had the option to run, that would be another story. It's really going to help if there are cameras here. This would happen in a parking lot of some kind. Nowadays, there's a lot of video going around. But generally speaking, in this situation, you do have the defense of necessity. And generally speaking, the defense of necessity, it has to be necessity to defend yourself from imminent harm. But the defense of necessity could often be used to basically excuse you from almost any crime. You're about to be killed, you kill that person, that's legal. Let's say you might be drunk, but then an emergency happens to where somebody's life may be in danger, but you don't have a cell phone, so you can't call the police for some strange reason, and you're driving drunk and you have to drive 3 blocks to get there or something. Well, that would be defense of necessity to protect somebody else's life, although normally you wouldn't be able to drive drunk because you'd get a DUI. But in this specific circumstance, if you don't have a cell phone, there's no way for you to get there, you can't call the police, then yeah, it'd be reasonable for you to drive to save that other person's life. So like I said, absolutely. If you're in the process of being kidnapped, you have every right to kill that person in order to keep yourself from being kidnapped, because you could very well be killed in the process of being kidnapped, or once you're kidnapped, you can be killed. So it's definitely reasonable behavior. So this is going to have to be very thoroughly investigated to really be able to push forward that you were legitimately trying to protect yourself from serious bodily injury or death. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation in court, give us a call for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was driving under the influence of medicine, criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.